Hey viewers, this is Dheer Ved from Zumet Capital and welcome to the last video on the EB-5 series. So today we are going to discuss the newly Reforms and Integrity Act of 2022. The EB-5 Immigrant Investor Program has gone through crucial changes in 2022 due to the newly formed Reforms and Integrity Act or the RIA. The EB-5 Reforms and Integrity Act was signed by President Joe Biden on March 15, 2022, which encapsulate a new law that recommended the new requirements for both EB-5 investors and the regional center. This act guarantees application processing in case the regional center program relapses. It is more important because when the EB-5 program expired on June 30th, 2021, USCI stopped processing the EB-5 applications. The Reforms and Integrity Act has been in force since 14th May 2022. All the regional center investors who file on or before 30th September 2026 are guaranteed that their applications will be processed even if the regional center program lapses. This is a 5-year long-term reauthorization of a regional center which gives investors the protection towards their investment. So now let's discuss the changes in details. The first is investment amount. For all the new filings, the investment amount is $800,000 if investing in a targeted employment area. It can be either a rural area, high unemployment area, or in the infrastructure projects. Otherwise, the investment amount is $1.05 million if investing in a non-targeted employment area. Second is grandfathering. In simple words, grandfathering means if you have filed the petition I-526 or I-829 before the Reforms and Integrity Act of 2022, you are eligible for the old law. This new law is applicable to the investors who file their petition. The old law does not stop the decision and the visa allocation process for the old EB-5 investors. Third is new forms released by USCIS. USCIS has released various new forms such as Form I-956, which is application for a regional center designation, Form I-956F, which is application for approval of an investment in a new commercial enterprise, Form I-956G, which is application for a regional center annual statement, Form I-526, which is immigration petition by a standalone investor, and Form I-526E, which is immigration petition by a regional center investor. On April 11, 2022, USCIS pulled out an update with respect to the Reforms and Integrity Act that old regional centers are no longer designated and they have to maintain the status again by filing the Form I-956. Without that, they cannot file for the petition I-526, which is immigrant petition for an alien entrepreneur. Once the USCIS approves the Form I-956 for the regional center, they can file for the petition I-526. The filing fee for the Form I-526 is $3675, and from October 1st, 2022, an additional fee of $1,000 will be applicable under the Reforms and Integrity Act. Fourth is visa set-asides under the EB-5 Reforms and Integrity Act. There are 3 new categories of the EB-5 new set-asides under the new law: 20% for rural area, 10% for high unemployment area, and 2% for the infrastructure projects. So let's take an example. A total of 10,000 EB-5 visas are allotted each year, and a 7% of EB-5 visas are allotted to each country. That is 700 visas are available in the EB-5 section. So 20% of rural area, that means 20% of the 700 visas, that is 140 visa are available in the rural projects. So those who have filed the petition I-526 after March 15, 2022 will be assigned a code that will mark him or her within any 3 reserved categories. The Department of State has declared that the reserved visa are only available to the immigrant investors who will file their petition after March 15, 2022. Fifth is investors protection. Reform and Integrity Act of 2022 allow investors to freely proceed with alternative entities if regional center, company, or a job creation facility closes. As long as their investment arrangements were qualified within 180 days of notice and action, they are allowed to associate with another entities who will meet their investment and job creation requirements. Sixth is adjustment of status. Existing investors in the United States can concurrently file to have their status changed, whether if I-526 is approved or waiting for the approval of I-526 petition. The applicant and the dependent can file Form I-485 to obtain or to gain a conditional permanent residency in the United States. This apply to the new investors as well, where they can file a Form 526 and I-485 together. Seventh is RC visa expiration. Regional center visa are available till September 2027, as they provide a long-term reauthorization of 5 years to the EB-5 investors. Eighth is indirect job limit. Indirect job for the regional center investors can count for no more than 90% of the jobs, and from which 75% of the jobs can be counted from the construction lasting for no more than 2 years. Ninth is project request. A regional center has to file Form I-956F for the project approval, but the EB-5 investors do not have to wait for their approval. Once the I-956 petition is filed, investors can file for petition I-526 10 days after the filing. 10th is sustainment period and redeployment. The new act states that the investors who file petition I-526 after March 15, 2022 require the capital to be invested for at least 2 years from the beginning. This means that the investors can receive the return on capital once it has invested for the 2 years, even if they have not become the conditional resident or have received the I-526 approval. And the last is the fund administrator. In the absence of a audited financial statement shared with the investors, the NCE must maintain the EB-5 capital in a secured separate account and retain a third-party fund administrator to ensure that the capital is properly flown to the job-creating enterprise. So, these were the main changes highlighted under the Reform and Integrity Act of 2022. Now we come to the end of the video and to the end of the EB-5 series. Stay tuned for the new video on the channel. Thank you.